Welcome to the Trade Advisory Network YouTube channel. I'm John Bougere, co-founder and managing director of Trade Advisory Network. On this channel we will produce a series of videos, short educational videos on a variety of subjects concerned with trade and supply chain finance. This first series focuses on URDTT, that's the Uniform Rules for Digital Trade Transactions, and this is episode 2. Now this series is made in association with ITFA, that's the International Trade and Forfeiting Association, and also with LIBF, that's the London Institute of Banking and Finance. ITFA have been very active in the whole digitisation agenda and have been very supportive of the adoption of UNCITRAL's MLETR, Model Law on Electronic Transferable Records, of which more later. LIBF is of course the preeminent educational body for the banking industry worldwide. For those of you that don't know us, Trade Advisory Network was founded in 2014 by myself and my colleague Lionel Taylor, and we are a trade and supply chain finance specialist consultancy offering consultancy and educational services to commercial banks, development banks, fintechs, technology service providers, educational bodies, investors and corporates. We also undertake expert witness assignments when trade and supply chain finance disputes end up in a tribunal or a court of law. If you feel that your organisation would benefit from direct engagement with Trade Advisory Network to refine and implement your digitisation strategy, develop your trade and supply chain proposition, or develop a bespoke education programme, then please drop me an email or check out our website. Contact details are shown on the screen and are also in the video description. Now this is episode 2, but in episode 1 I provided some background to the creation of URDTT and discussed two essential concepts. The concept of a digital trade transaction itself, or a DTT as we sometimes abbreviate it, and also the use of electronic records. I will cover these concepts in more detail in future episodes. In this second episode I'll provide a high-level overview of the two fundamental elements that are central to the function of URDTT. And these are the payment obligation and the FSP payment undertaking, which I will explain shortly. First, let me quickly consider the positioning of URDTT relative to other ICC rules and also relative to ITFA's DNI, Digital Negotiable Instruments Initiative, and UNCITRAL's MLETR, which I've mentioned a few times already. URDTT is conceptually quite different from other ICC rules. For a start, it doesn't relate to a specific bank product, unlike UCP, for example, which relates specifically to letters of credit. Secondly, URDTT is not bank-centric. The rules address the rights and responsibilities of all parties to a DTT, but the principal parties are the seller and the buyer. The role of the bank is of course specifically addressed, but we've broadened the definition to include non-bank finance providers, hence the reference to financial services providers, or FSPs. Unlike the existing ICCE rules, EUCP and EURC, which are supplemental to UCP and URC respectively, URDT covers transactions which are executed and evidenced solely in the digital space. Those existing e-rules are product specific, clearly, and also accommodate a mix of digital and paper presentations. To a certain extent, ITFA's DNI initiative and UNCITRAL's MLETR go hand in hand. They both focus on the use of digital negotiable instruments. The DNI provides a technology specification for the creation and management of a digital original payment instrument that is functionally equivalent to a negotiable payment instrument such as a bill of exchange or a promissory note, which traditionally would have been printed on paper. Full details are available on the ITFA website. The technology to deliver the required functional equivalence has been developed by a company called Enigio, a Swedish technology company, and this technology, these applications are now commercially available. Full details of the application and the use cases are available on their website, so links to the ITFA website and the Enigio website are shown on the screen and also included in the video description. MLETR is effectively a template for new legislation allowing the use of digital negotiable payment instruments and documents of title. It's been enacted in a number of influential markets already, including Singapore, Abu Dhabi and Bahrain. Most importantly, at the G7 summit in 2021, all 7 nations plus the EU committed to enacting legislation that is compatible with MLETR. Here in the UK, the Law Commission has undertaken extensive research and has drafted legislation which will be put to Parliament in Q2 2022, that's this year. Speaking of the UK, negotiable payment instruments are subject to the Bills of Exchange Act of 1882. Not surprisingly, when the Act was written, the authors did not envisage the emergence of digitisation. That said, there is nothing in the Act itself that dictates that a Bill of Exchange must be written on paper. The problem with the Bills of Exchange Act concerns the concept of possession. Under English common law, it has been held that it's not possible to possess an intangible, and an electronic record is, of course, intangible. In order for a Bill of Exchange to be a Bill of Exchange, you have to be able to possess it and deliver it. The trade finance practitioners amongst us will know that the characteristics of a Bill of Exchange that make it useful in financing trade are, amongst other things, its negotiability and its autonomy. The holder of a Bill of Exchange has an unconditional and irrevocable right to get paid. In order to exercise that right, they have to present the accepted bill to the acceptor for payment, which is the delivery part. When we talk about autonomy, what this means is that the right to get paid is independent of the underlying contract to which it relates. In other words, contractual dispute is not a defence against non-payment by the acceptor of a bill of exchange. This characteristic is very useful to finance providers as their source of repayment is not, as a result, subject to any issues concerning contractual performance. The problem is, if you can't possess an intangible, you can't be a holder. So if you can't possess a bill of exchange, you don't have a bill of exchange. The ability to transfer the right to get paid is also crucial to the concept of negotiability. Under the Bills of Exchange Act, you can transfer the title rights by delivery of the instrument to a new holder in exchange for value. Unless the instrument is made out to bearer, the transfer must be accompanied by endorsement by the transferor in favour of the transferee. Once again, if you can't possess an intangible, you cannot transfer ownership to another party. The changes in the law will address this, and coupled with the technology developed by Inigo, it will be possible for an electronic record to be interpreted legally as a digital bill of exchange under the Bills of Exchange Act, which is basically what MLETR is seeking to achieve. It will therefore be possible for a payment obligation, as defined in URDTT, to be a bill of exchange, allowing the benefits of its negotiability and its autonomy to be fully realised in a wholly digital environment. So now let's look at the payment obligation as defined in URDTT. At this stage, I will provide just a high-level definition. In a later episode, I will provide an in-depth analysis of the rules governing payment obligations, but we'll leave that for a little later. According to Article 2 of URDTT, a payment obligation is irrevocable. It may be conditional or unconditional, and this is an important point. Bills of exchange are inherently unconditional, so this is a difference. It is incurred by a buyer, which means it's a corporate payment obligation, and it's a definite undertaking to effect payment. As mentioned in the previous episode, the buyer's obligation to pay is triggered by submission of electronic records that comply with the digital trade transaction. Now, in a sense, this is similar conceptually to a presentation of physical documents under a letter of credit. That's what triggers the conditional obligation under the LC and makes it unconditional. Payments may be required at sight or at a fixed or determinable future date, similar to a bill of exchange. So having recognised that a payment obligation is a corporate instrument, where does that leave the banks? Well, that's where the FSP payment undertaking comes in. As mentioned, the rules do not restrict the financing activities to banks, so we refer in the rules to a financial services provider or an FSP, being any financial institution or person other than a principal party, seller or buyer, that provides risk mitigation or finance, effects payment, or adds its FSP payment undertaking to a corporate payment obligation. The use of the word person there actually in law means a living person or a legal entity, so don't worry about that. Now, an FSP payment undertaking can be added to a payment obligation at any stage, including when the payment obligation is still conditional, has not yet become unconditional. And once an FSP payment undertaking has been added to a payment obligation, it becomes inseparable from it. The two are attached. Comparing an FSP payment undertaking with traditional trade instruments, we could say that an FSP payment undertaking added to a conditional payment obligation provides risk mitigation or risk transfer, which is conceptually similar to when a bank issues or confirms a letter of credit, depending on whether it's the buyer's bank or the seller's bank making the undertaking. An FSP payment undertaking added to an unconditional payment obligation is conceptually similar to an avalized bill of exchange or an acceptance under a letter of credit. To conclude, for now at least, and to inspire you to look out for the next episode, let me leave you with one final thought. A conditional payment obligation is linked to the DTT, but is independent of the underlying commercial contract. An unconditional payment obligation is independent of both the DTT and the underlying commercial contract. On that note, please keep well, stay safe, and until next time, goodbye.